Good morning, everyone. For those that don't know me, I am Stephen Kelly. I'm Chief Executive of Manufacturing Northern Ireland. You're all very welcome along to this webinar this morning. Before we start, just to say that do take the opportunity to ask whatever questions you may have, put them into either the Q&A function or the chat function. And after we've had the presentation, we'll get an opportunity to go and inquire about those questions on your behalf. We will be sharing a recording of the webinar and the slides after the event, so don't feel that you need to be scribbling like crazy the information that you hear. Obviously, the slides in the webinar will be informative, and do take your own notes if you require that. Very pleased this morning to welcome along David McNeice, who's a partner and the Global Head of Infrastructure and Construction and Energy with DWF Law, and his colleague Anya McGuinness, also in the same part of DWF, who will take us through this morning on the issues of good record keeping and the value and understanding of good record keeping, particularly in relation to claims. Obviously, we live in a very litigious world. We don't want conflict with either customers or consumers or supply chains for that matter. So actually having a good relationship and ensuring that there's clarity and certainty for all parties involved is really, really important. But sometimes things do go wrong. And when they do go wrong, it can be very painful and very expensive, of course, for all parties involved. So actually understanding the value of good record keeping is really, really important in order to protect you and protect your business and protect the relationships that you've established through your businesses. I'm going to hand over in a second to David and Anya, but just to remind everyone that we are recording, we will be sharing a recording and the slides after the event. So I'll hand over now to David and Anya, and we'll come back to you at the end of the presentation with an opportunity to answer your questions.
Thank you, Stephen, and thank you for the introduction. We are delighted to be here today to talk to you all on the value in record keeping and understanding claims, and hopefully you gain something from the session today and you can go away feeling a little bit more confident should issues arise on your project. So before we begin, we thought it would be useful to just talk you through why we are sort of well placed to be able to talk to you about this kind of stuff today. So my background is predominantly in disputes. So I do a range of different disputes, whether that's during the life of the project, if claims arise or issues arise, we help clients to try to resolve those issues as and when they arise, and then try to help clients to avoid going to more formal dispute resolution processes if that's the desire. And then equally, if you get into a more formal dispute, trying to navigate that process with you and assist where we can. So that's why we're quite best placed, or we're well placed when it comes to understanding what it is that you need when it comes to claims in terms of that factual evidence and the importance of record keeping. Going to do a brief intro?
Yeah, similar to Anya, I'm a terribly contentious person by profession and nature. But I also am involved quite a bit at the front end, so more as a projects lawyer. So we can sort of see the front end, the life cycle of a project, and often dispute resolution. Now we tend to focus on dispute avoidance, and as I'm sure, practically, commercially, and often pragmatically, that's the best approach to take, is how do we avoid disputes, and often it's the weapons you have in your arsenal to help you do that, and there is no better weapon that you have than the records that you would keep throughout the life cycle of the project. And really that's how we want to kick off and make this a very practical session. Look, Stephen said there's going to be questions at the end. Look, there is no such thing as a stupid question, so please, anything you'd like to know, we're more than happy to take the time and go through those.
Great. So in terms of the agenda for today, we'll try to take you on a bit of a journey through how we get to that claims process at the end, and why the records are important and why having accurate records is particularly valuable when it comes to claims or challenges on your projects. Then how to effectively manage those records. So how do you store them? How do you make sure that you have access to them as and when you need them should issues arise? And then we're going to briefly touch on AI. Obviously, there's a lot of chatter in the market about artificial intelligence and how you can use it potentially effectively within your businesses to manage your records. And then we're going to then look at how to prepare and present your claims, having considered then the value in those records, how to build up your claim using your factual evidence, and how to avoid going to more formal dispute resolution processes. So starting with the art of record keeping. So why do we have records? Why are they so valuable? Why do we need to keep records stored and make sure that we have access to them? And this all comes down to the 2 points at the start of the slide. It's the burden of proof and the standard of proof. And the burden of proof is essentially producing your evidence in order to establish the truth of the facts. And what that really means is that, it's bringing together the information that you have in order to demonstrate to whoever it is that you're bringing your claim against, the truth of my event or the truth of how I present my claim is correct. And when it comes to a more formal process, there's of proof when it comes to civil claims, which would be the scenario that you would be in, should it be a construction claim. It's all about the balance of probabilities. So forget about the reasonable doubt that you might have heard in suits. This is all about the balance of probabilities. It's about looking at the scales and trying to weigh up, do I have enough factual evidence in order for that deciding body to determine that, yes, I am satisfied with the information put before me, with the facts that I have, that yes, the truth of the matter is more likely than not yours. Your truth is more that you've been able to satisfy that truth better than the other person. And that's where the factual records come into play. That's your evidence. That's how that person's going to determine that. It's looking at the contemporaneous records, so the records from the time the event occurred, but it's also looking at first the contract. So what did your contract say? What was the scope? What did the parties expect to do? Then what happened? So what was the change? What has occurred in order for that contract scope to have changed? And then what was the effect? What happened? What's the cause, or what's the overall outcome? So have you incurred additional costs, or are you out of pocket because you haven't been paid, for example? And it's building that picture, getting your contract and your scope. What did it say? What did we have to do now? What was the cause of the issue? And what's the effect? So this is starting to look at how you build your claim, which David's going to talk about in more detail later. But that's really the crux of it. It's looking at, can I demonstrate my truth with my factual evidence? Does it tell the person that's going to be deciding this that my truth is more likely to have happened than not? And that's really what this is all about. It's, being able to look at the planned and actual and able to establish, is that correct? Is my truth more likely than not to have occurred? And without your records, without your factual evidence, what are you relying on? It's potentially witnesses, factual witnesses who are talking to evidence who don't necessarily or potentially aren't going to be accurate. So what we would prefer from a disputes perspective is that your factual witnesses talk around the documents. They're able to fill in the gaps, but you have that factual evidence to be able to demonstrate the truth of what happened at the time. So who do I need to convince? Really, yourself and your boss are the first two. Can I convince myself with the information that I have? Am I satisfied that how I present this and it doesn't have to be a formal dispute. This can be during the life of the project when issues arise. Are you confident with the factual information that you're presenting that you are going to be successful with whatever that claim is? And although you're always looking at this from the eye of someone who's making the claim, consider yourself put different hats on. Think about it from a project manager or a client's perspective. If they look at this, how are they going to view it? Are they going to, on the balance of probabilities, be convinced and satisfied that yes, you are entitled to those additional costs, or you have done that work and therefore are entitled to be paid, whatever the case may be? And then you have your ultimate deciding bodies. So you have the adjudicator, the arbitrator, the judge, who will be looking at it more carefully in terms of the balance of probabilities. And really that's what, it all comes down to, going back again, always to that burden of proof and establishing, are they going to be satisfied? And is your evidence compelling enough for them to determine that, yep, I am satisfied that you are entitled to those additional costs, or whatever the case may be. So then it's, how do we do that? How do we convince those people?
And you break down in different ways the manner in which you would convince. Now, you start with your contract. Now, any contract can be in writing or oral. So I don't necessarily need a script. I don't need a set of terms and conditions to have entered into a binding contract. But why people grit their teeth and have to engage people like myself and Anya is to put those contracts in place, is to provide the certainty of what it was that you contracted on the basis of. So as Anya said at the start, first principles, you look at what was done, what happened, and why that changed, that issue of cause and effect. So the first thing we say is, we'll pick up your contract. What does the contract actually say? So let's not look what went before it. Let's not look at what's happening now. Let's look at the point of time what I agreed to. So what does the contract say I am actually entitled to? Does the contract spell out that in the instance of X, I can claim Y? In the instance of a delay caused by an unforeseen condition, an unforeseen event, I am entitled to time and money, or perhaps only money. So first off, we look at the actual written word. We then have to go past not just the entitlement, but barriers or hurdles to that entitlement, issues of notification, time bar. What does the contract say I need to do by way of evidence? Does it need to show money spent, that there has to be costs, or can it be damages that I have not yet incurred? Does it demonstrate or require me to demonstrate any form of mitigation beyond what the law says? So again, these are all things we need to consider. So first off, we look at the actual contract itself. Then we go back to, well, what got us to that situation in the first place? Why did I contract on that basis? What assumptions did I make at the time? And one thing we always say to look out for within your contract is an entire agreement provision, or words to that effect. Essentially a clause that will oust anything that came before the four corners of that contract. So whenever I enter into that contract, do all the discussions, all the debates, all the negotiations, all the assumptions that I made, all the clarifications, if this is a public contract going through the as now as Procurement Act, what basis do they have on the actual agreed terms? Because if that entire agreement clause ousts that, well, tough luck. And the Supreme Court has made very clear, Dems to Brex, I'm not going to interfere if you've made a bad deal. So you really need to make sure the contract is clear and certain in what I believe is going to happen, what I have to do. And then, can I bring in any of the information that occurred before or happened before the contract? And we then make a very short point about contra preferentum. That's when we talk about ambiguities. Two different things we always need to worry about whenever we look at the contract itself. That's an inconsistency. That's when two different things conflict. And an ambiguity. That's when I can interpret things in two different ways. And if I look at contra preferentum and there's an ambiguity, I'm not entirely sure what that clause means. If I had an equal bargaining power, I could have just said no to the contract, but I still went ahead and entered into that contract, or we had any form of negotiations. This saving grace of contra preferentum, the fact that the clause might be slightly ambiguous, it isn't going to save the day. I think it's a lot of people who tend to tout it to do. We also then look at whenever we consider the tender, we look at, well, what was the original program and price? How long did I have to provide a service or carry out works? How much was I going to be paid? And again, it's back to the first principles I just talked about. What was I meant to do? What has changed and why? And this is where we start getting into the story, because any kind of claim is a story. And it is, once upon a time, I entered into a contract. Something happened, and the effect of that was X. And you employ people like ourselves to help tell that story. So we can get you the script, we can hold the pen, but you need to help us fill in the blanks. It's one of those stories that, remember, back in the day when you would read something, you would enter a puzzle and turn to page 10 if you got it right, or page 11 if you got it wrong. That's the information you need to give us. You need to tell us the story that we go on. And the amount of records that you have help inform that. Help decide whether or not this is going to be a bestseller, whether or not you're 50 Shades of Grey or Harry Potter, or instead some GCSE non-fiction that you would have written back in the day. So how do I help you tell that story? And we look at outside of the contract, outside of the tender, more granular physical evidence. So the first thing we look at is, well, contractual compliance, the information that you have that the contract would tend to require you to possess. That's the program and any progress schedules. What did you actually do? Where's the contemporaneous evidence to demonstrate what was your plan and how was that being executed? Claims that you'd made, the information of valuations and payment certificates, the actual tangible physical evidence to show here is what I am telling you I am owed because the contract requires me to do that. And that's the very basic. That's just a square one, the information you should possess. It should be there and at hand. And that starts the building blocks, the foundation of this record keeping, of the information that you would make to advance a claim. Then you go on physical on-site evidence. So your site records, who was on site at the time, or what services were being provided? How can I show plant, labor, equipment allocation sheets? Who was doing what when? Records that I have paid people. Records of site meetings, what was recorded at the time whenever people were physically viewing the site. Photographs evidencing what was happening at the time. We had a construction claim many years ago working for a subcontractor who was claiming themselves in delay. One of their issues was fenestration. They couldn't install the windows. They said, well, we couldn't install the windows because the wall wasn't built at the time. And there was a lot of back and forth as, oh, well, the program actually says, no, we were on schedule. And at the same time, we were able to produce photographs of the building not yet constructed to say, well, that doesn't accurately reflect what the program says. So again, it's the amount and credibility of that evidence. Then you've got correspondence, the actual information between parties, what was recorded on site, if there's confirmation of verbal instructions. And Anya will talk later about that email discipline or very simple ways that you don't even need to use the artificial intelligence side of things, but to just start recording and filing information in the right place. And if you really need to clutch at straws, the likes of site diaries that can show a personal account of what happened on site. I'll very quickly tell you a story of why it is important that those are saved contemporaneously. Many years ago, we were working in a project in the Highlands of Scotland. It was a landfill. Whole point was the HDP lining was to go shiny side up or rough side up. Specification said it was to go shiny side up. First 5 landfills had been constructed in this way. Thereafter, it went rough side up. We were on for the contractor. Contractor said, no, we were told on site, individual on site, contract manager instructed us that they were to go rough side up from now on. But there was no email correspondence. There was no change order. There was no instruction that evidenced that. So the adjudicator in this instance had to decide whether or not our client, the contractor, was not being entirely accurate in their account of the conversation that happened, or was that account credible? And what evidence did we have? Well, we had no contractual evidence. We had no on-site physical evidence. So all we would have was the off-site or the personal evidence. We had nothing supporting that. So I had said, look, even do we have a site diary, anything even internal that demonstrated this? Contractor scratched their head. I'll come back to you, David. About a week later, came back, put a diary in front of me and said, there you go, David, that's the silver bullet, the smoking gun, we've got them. And I picked up this brand new crisp book, fresh out of Waterstones. that said verbatim what I said it needed to say, dated on the date in which they said that instruction was given, with no other entry. Now, I was not accusing my client of lying, but I asked whether or not this was saved contemporaneously to demonstrate that this wasn't, as the other side may allege, basically just manufactured now to help support this claim. And you could still see the ink smudges on the client's hand. But they came and said, oh, well, no, I suppose. No, it wasn't saved at the time. We don't really do that. And because of that, we couldn't use that evidence, even if it was, because it didn't have any credibility. So it's not just about having an amount of records, it's the credibility of those and what it goes to speak to. The last type of claim is actually whenever someone can do the job for you, whenever a member of your supply chain, subcontractors have made claims against you, and that's a claim that we're then forwarding. So again, one of the things that we can always do is rely upon what are the evidence that other people are gathering that help support our claim. So again, it's what those then actually look like. But whenever we think about the records themselves, we have to consider how we actually can effectively manage those records themselves.
Yeah. So now that we've talked you through why the records are important and what the records are that we're discussing and why they're of value, it's a case of thinking about, well, how do I store them? How do I make sure that I've got access to them when I need them, and when do I need to start that process? And the short answer is from the very beginning. And that can be even at the very, very early stages. If there's a procurement process and you have tender documents, those tender clarifications can become useful down the line if there's a dispute in relation to what was agreed at the early tender process. And the process itself in terms of organizing them doesn't have to be sophisticated. It doesn't have to be complicated. It can be very, very simple, as even just organizing it on your internal drive. If you have one within your business that enables you to store and access documents. I think the key is organization. From the very beginning, have a document management system in place where you store documents, you know exactly what the system is, what documents go where, stored in relation to specific events, and have the people who are involved in that project all on board. Everyone needs to understand what that system is. We can't tell you the number of times on disputes that the issue with poor record management becomes the key problem, that we cannot find records that would be very valuable and the client's convinced they exist, but it's just impossible to find them. And the key is also centralization. It's ideally having a sharing platform, because when we discuss having something on your internal drive, if a project team or individuals who are on site don't have access to that on a regular basis, that can quite quickly become out of date, or it's not live and it's not being updated regularly. So having a sharing platform or a cloud, for example, we use SharePoint, and you can upload information onto that database on a daily basis, and it's up to date. Having something centralized and live keeps everything up to date, keeps everybody communicating and keeps everyone involved, and that's really the key. The more comprehensive systems are the likes of CMAR and Fast Draft that are used quite regularly in the construction industry. The challenge with that is that there's obviously costs associated, but also things like emails, chains of emails aren't automatically stored on that system. It's the same with every record that's uploaded. It has to be physically uploaded onto the site. And so if there are a chain of emails, it's on that person to ensure that that record is adequately uploaded. So keeping a record and keeping it from the start and keeping it organized is really the key when it comes to when a claim or an issue arises, particularly for us. Hopefully you won't have to instruct us, but that's what you need to think about is, well, what is it that I need and how quickly can I get to it? So we discussed that we would touch a little bit on AI and how AI could potentially assist with record management and beyond in the construction industry. Now, there's a lot of traction at the moment on artificial intelligence and how it's becoming particularly popular in the construction industry, but also globally. But it's very slow. The uptake in the construction industry is actually very slow, believe it or not. And I think it's probably comes down to not a lack of understanding. It seems a bit worrying around the potential risks associated, and so not a lot of people are there's not a lot of uptick as a result. But ultimately, and as the title says, maybe that's a little bit too elaborate, but it's essentially computer science that endeavors to simulate human intelligence in machines. But ultimately, it's just more advanced and sophisticated technology, the benefit of which is purely to increase efficiencies. And in the construction industry in particular, we're all aware of the wealth of documents that are involved. You know, if you have the contract in place, it itself can be voluminous. So having all that data in one place, having it centralized, having somewhere where things can be organized would be incredibly beneficial, and especially when things move very fast on construction projects. So examples, there's a document management system called FieldWire, which is a live and centralized storage system. It can be accessed anywhere. You can upload photos, drawings, RFIs, all those documents that are, you know, they're being updated on a regular basis. And it means that there's good communication then between the team who are on site, or the team who are perhaps not on site on a regular basis. Then you have the likes of Chime software, and it's more of a project management tool. And it's useful for having digital timesheets, your health and safety records, where they can be signed by parties or by members of the team and uploaded then onto the system. It's good for managing your equipment and plant. And it's also useful for tracking your operatives, understanding where they are on site. All the things that tend to start to become an issue when a claim or an issue arises, if you have all those records in one place, you know, you're flying. Now, that technology is only the tip of the iceberg in terms of the other technologies that exist in order to help the construction industry. Delays are, you know, they're commonplace in construction projects, and there's two other softwares, Doxel and BuildDots, and that's all about monitoring progress. They use computer vision in order to keep an eye on the site and establish and predict and forecast whether there are delays potentially could arise. And, you know, that's useful from a, you know, mitigation of risk, and being able to be more accurate with programs, so that you can establish, well, this potentially could cause a problem down the line. Let's look at that. As with anything, there are risks. As with anything new and something that's transformative for industries, there's a concern around, well, what do I need to be worried about? Data breaches tends to be the big one, confidentiality, but ultimately that's a concern that we have now, no matter, you know, forget about artificial intelligence. That's something that happens regularly. What these systems can do for you, the benefit of it, I think outweighs all of those risks. There's also risks around, you know, we've heard a lot about hallucinations and the accuracy with which these tools work, and the data that you put in, how accurate the outcome is. You know, what if that delay issue isn't actually a problem and it forecasts something wrong? You know, that's something that we will have to look at down the line from a disputes perspective. You know, what happens if it's actually the bot, the tool, the system that's got it wrong, and not the party? So all of these are all things that's probably going to become more live as and when, you know, these issues start to arise. But in terms of how we move forward and how you as a business, I think it's worth really considering how AI can benefit you as a business, because it's coming. Whether or not it comes in the next 5 to 10 years, I think it's probably coming faster than we think. And I think considering it now and how it could potentially benefit your business, and types of things you could start to implement, it's very worthwhile starting to invest in it now, because I think if you don't, you may be on the back foot. So let's move on now to preparation and presentation of claims. So now that we've talked about the value in your evidence, the value in those documents, how to store them, how to record them, how to keep them accurate, now it's really a case of, well, how do I take all of that information and then prepare my claim? Preparation and planning is really key when it comes to providing or determining what my claim is. You know, we've talked a bit about the burden of proof, and we've talked about cause and effect, and how we look at the contract, determine what happened, why it happened. And everything comes back to that balance of probabilities. It all comes back to, well, do I have enough evidence to determine the truth of my case? And the basis of the claim probably comes first. You know, is it the contract? Is it the terms and conditions? Have I not been paid? Am I entitled to be paid? Then we look at the factual evidence. Did the purchaser sign our terms and conditions and therefore agree to that payment process? Have we done the work? Have we manufactured that equipment? Have we not been paid? And these are all the things that you need to think about in terms of building up your claim. So we have the contract, you agreed to that, you have your invoice, we did the work. Here's a summary of what the work was that we did. And that's the factual evidence that you need, to determine that you've complied with the scope. Here's the invoice, we issued it, they haven't complied with the payment terms. That's a very, very high level story. But that's the way we would start to build up your claim. And then it's using the burden of proof, the balance of probabilities. Do you have enough weighted evidence for that deciding person to determine, yes, I'm content that's the factual truth of what occurred? And as I say, it's about the importance of fact. It is that factual evidence. And we put case at the end, but really that just means keep it short and sweet, short and succinct. Keep it focused on the facts, focused on the information, focused on the evidence that you have, and keeping a record of it so that you can go back and access it quickly. Now we have considerations.
And again, always those the presentation and the preparation of any claim, we have to then think, well, how do we do that, and practically, what does that look like? So again, as Anya said, the burden of proof means if I'm asserting a claim, I have to prove it. So if I say that the sky is green and the grass is blue, the burden is on me to show that I am right, and what you believe to be true is or what you believe to be fact is wrong. And that's my job. That's my job as a claimant. And again, you get into claimants, defendants, anyone advancing a claim, anyone bringing something. Obviously, I have to prove. If I am asserting something, if I tell you that I want you to believe my story, well, what have I got to back it up? Other things we need to consider is, well, if I have a claim against you for time and money, have I done everything that I needed to under the law? So is there a barrier, or is there a bar to my recovery? So whenever we look at that, we say, well, did we actually mitigate? Did we mitigate the risk at the start? Did we reduce the likelihood of that risk materializing? Or did we mitigate the actual loss whenever the event, the issue that the claim arose from actually happened? So after it happened, did I just sit in my hands and wait to befall pain? Or did I actually do something that would have reduced the impact of that? Because again, these are legal burdens on us. So it's not enough that a claim has happened to say, well, therefore, you now have to pay me. That only occurs on an indemnity basis. And unless the contract spells out that something is provided on an indemnity basis, which for most supply agreements will not exist, unless they are the client expecting an indemnity from any supplier, we always need to consider, well, have we done what we need to? And again, those common law provisions or principles. And again, we consider, well, can I prove that the event that happened has directly led to the effect that I'm feeling? And that's that cause and effect. That's a direct link between event and impact. And if we can show there were lots of different events and I've suffered a loss, we refer to that generally as a global claim, something that I cannot pinpoint exactly the direct link, but that doesn't defeat my claim. But whether or not I can connect that link is another consideration we need to have. Then have losses been apportioned, and it would have been reasonable for me at tender stage, and again, that entire agreement clause that we talked about. And with that, we look at the anatomy of a claim, and that is any claim whatsoever. It does not matter if this is a claim for buying a Mars bar, buying a car, or instructing for the manufacturer's supply of 100,000 widgets. It doesn't matter. Every claim is made up of 4 core principles. The first is entitlement. Is there something under the contract or law that allows me to claim? Have I taken all of the risk for X, Y, and Z? Or where under the contract can I point to and says, it is because of that provision, or under the law, it is because of that event or that occurrence that allows me to claim something from you? It's the records we use afterwards to ascertain how much that might be or the legitimacy of that claim. But the claim is defeated at square one if I cannot prove that I am under law entitled to something. After I pass that hurdle, that I can point somewhere to say, yep, that's a claim, I have to show that there's a liability. Liability is just a fancy word for responsibility. Lawyers tend to take ordinary words and call them something different to make ourselves feel smarter than we actually are, or to legitimize charging you for that service. But liability just means responsibility. So after I can prove that there's a claim, I have to look, is there anything that limits the responsibility of the party to pay, or my responsibility in actually either mitigating or doing something I needed to? So with that, we look at condition precedents. Do I need to notify under the contract? So the event may have happened, but do I need to tell you that it's happened within a certain time frame? Is there anywhere in the contract that says, well, whilst there is an entitlement to X, it will only materialize if the delay is longer than Y, or if the event has caused you losses exceeding a certain amount? So are there limits to that liability or that responsibility? Then, after we pass those two hurdles, I am entitled to something, and nothing bars or limits that claim, or if it limits, it doesn't extinguish that claim. I look at quantum, and that's time and money. What am I asking? What do I want at the end of this? Do I want more money to carry out more services? Do I want the profit that I would have made on work that weren't carried out, or the work that were omitted, or new works that were provided? So is this just about margin and not actually the physical expenditure, because that wasn't a cost to me? Is it just time? Do I want more time to do something? I'm not really interested in being compensated financially. I just don't want to get hit with delay damages or liquidated damages or penalties for not having done something. And what we often say is, don't start there. If there is a claimant coming to you, they're going to start on the time and money aspect, the quantum aspect of any claim. But that's not necessarily where we should start. Because if I start and engage, so Anya has a claim against me, and Anya says, right, okay, I'm entitled to 20 days and £100,000. And I say, right, okay, well, actually, I don't think that's at all true. Well, why do you think you're even entitled to that? You know, and she starts going into the time and money conversation. Have I in some way legitimized the claim itself before actually going through the first two hurdles, or passing those? And after we establish that, and quantum really is where the records come into their own. Records for entitlement liability is more about the notifications. What does the contract say? Those first two pillars of information we would need. Quantum is all the other stuff. Where's the site record? Where's the evidence of the money spent or the time incurred? The programs, the progress schedules, the minutes, the photographs, all of that really good tangible stuff. And after we present that, implementation, that's basically, how do I want that claim to take effect? Do I just want the money paid and the contract price increase? Do I just want the completion date to be extended, or the date for delivery to be extended out? Do I want this to be implemented via a decision, by a declaration, by agreement, by settlement? So implementation is just how that claim takes effect. And we either have to go through a formal dispute resolution process, or we mitigate the risk of that and mediate, conciliate, or just negotiate, just settle a pragmatic and practical or commercial position. And often that's what we tend to look at. And before we go to the full-blown dispute resolution process, we look at how we can de-escalate, how we can take the boiling pot off simmer and just let things calm down. Well, the first thing is, whenever a claim comes to you, or you're advancing a claim, stop, look, and listen. Is there actually a claim here? Am I going to end up expending good time and good money throwing a claim because of the value of it, whenever legitimately it's really not worth it? And actually, stop, look, and listen. From a defendant's point of view, what's the cost of adjudications, of litigation, and is there a horse trade? Is there a commercial? Is there a pragmatic solution here? We often say, anytime anyone is claiming, or you want to understand it yourself, put it down in paper. Get a contemporaneous record of what you think the claim is at the time, because things may change. So that helps us understand a bit of a risk assessment. And again, people come to us more often than not when de-escalating disputes, just as a risk assessment and an options paper. Well, how strong is this claim? Give me a chance, give me a percentage chance, very roughly, as to, do you think it's better than 50-50, or do you think I'm on to a loser here? And what's the costs? And then spell out the commercial, pragmatic, or practical options that are available. Understand the claim, assess the merits and the alternatives. Well, even if I can't advance this claim, is there something that I'm really actually after? Thinking about the implementation. How do I want this change or this claim to take effect? Use the contract and avoid a dispute actually coming to the fore. Continue to negotiate, continue to work together and collaborate. And sometimes you can use without prejudice conversations to do that. And this is the only point I want to make on without prejudice communications, is to not believe that just by saying something is subject to contract or without prejudice, suddenly then veils me in such a way that I can never, or it can never be used against me, the information that I share. If you want to genuinely talk on a without prejudice basis, both parties need to agree that that is the intention, that's the fact, that's what we want to do. And two, the without prejudice conversations have to genuinely be in the advancement of something being settled. We've had a number of occasions, and this happens more often than you would think, that somebody says, without prejudice, if you don't go away, I am going to sue you. I am going to walk off site. I am going to come after you with all hellfire. That's not without prejudice conversations. That's just something I'm not comfortable setting in open correspondence. So it has to legitimately actually be with a furtherance of settling or working towards a resolution. So without prejudice isn't a catch-all, does not cover you. And always be aware that sometimes the correspondence that you are issuing won't have that protection just because you've marked it as such. And it's really something we should use carefully. The other types of privilege that we would tend to use is legal advice privilege and litigation privilege. I don't need to spend too much time on them, but often to say, anytime you're ever thinking about engaging a third party, a consultant, an expert, somebody from a technical basis, it's always best to use a lawyer, because the information that's shared between both of you is not privileged. And if we end up in arbitration or litigation, that's discoverable. The other side can see that. So if I go to a third party and the third party says, yeah, your claims are rubbish, and actually you're entirely in the wrong, the other side gets to see that. The other side gets to see the fact that you had that information and then didn't share it. Often lawyers use legal advice privilege. So we would instruct that party, that third party, meaning that veil, that protective veil of privilege applies. So again, just always consider what the available options are. And that hopefully then ends almost bang on time, which is like a rare thing for the two of us. To hand back over to Stephen for comparing any questions you might have.
David and Anya, that was really good. Thank you so much. It was I mean, this is an area that scares people a lot. So to actually have this defined in a simple, understandable, systematic way, was incredibly helpful, which I certainly greatly appreciate. I'm sure others do as well. We have a couple of questions, but I'm going to kick off with some of my own, if you don't mind, and then we'll get to the other couple of questions. And if other people have questions, haven't heard all that's been said, then please do drop them either into the Q&A or the chat. David, you started off by saying that you're contentious by profession and by nature, which I thought was an interesting introduction. But the whole way through this presentation, it was all about trying to avoid conflict and trying to avoid litigation. And I think that's a constant surprise for many people, that lawyers actually don't like to litigate. Lawyers prefer to try to find solutions for customers, clients, before the need to get to court. And in some respects, if you get to court, there's a failure there between all parties. And you kind of finished on that basis as well, in terms of trying to look at ways to de-escalate that they go on. But at the core of all of this is potentially the contract, and you define them as some of them are 50 Shades of Grey or Harry Potter bestsellers, and others are pretty rubbish. I mean, how common are really poor contracts in your view, from either side of the table?
Very common. So it often comes to pass that there are contracts that are made with a spit in the hand and a handshake or written on the back of a napkin, in such a way that, well, we've been dealing with these people for years, and that's the way that we do business. And that should never, ever leave. And again, just as opposed, but before continuing that point, a bad lawyer looks to profit themselves and think, well, this is a claim, and that claim needs to go to court because then our fees are recovered. Lawyers don't advise, good lawyers don't advise just on the legal aspects. Our job is to advise on the political, the commercial, the pragmatic, the practical, and then the legal. Our job is to advise you through the minefield of disputes or of contracts or of the management or administration of contracts, depending on different stages. And on the per contracts, they either come because I trust you. And again, that's one of the things that the lawyers then tend to breed distrust, because the moment you get a lawyer, someone else has to get a lawyer as well. But as one party then becomes more sophisticated, the individuals that I have been operating with over the last 20 years perhaps move on. The family nature of the business advances, and the turnover of £500,000 is now 5 million, is now 10 million, is now 50 million. And those structures update. And then suddenly the people that they have in place, or the mechanisms that they use to enter into contracts, move on, but we don't. So we need to keep constantly evolving and catching up. And the contract just gives that certainty. And lawyers should not get involved in the commercial aspects of the deal itself, only involved in what commercially benefits the party that we are advising. And it's never losing sight of that. So bad contracts happen either because trust and people move on and don't catch up, mistrust because I don't trust that this isn't going to happen, so I contract in such a way that there's such unreasonable terms that no normal person would sign up to, but I haven't read the contract. Well, I'm still bound by the terms irrespective of reading or understanding. And perhaps I've sold away the rights to my firstborn child by signing up to those those agreements. And usually that's where we come in, is just to say, well, actually, look, this isn't in your interest. Now, you can commercially take that risk. You just need to be advised of that risk. But it is all well and good, this session, this seminar. That's an endemic, that's a cultural thing within the industry, within all industries, that sort of per contracting practice isn't going to go away. It's just how can we advise members of manufacturing and to look at the warning signs. And often one of the easiest ways to do that, you don't need a lawyer to do this, is just understand your business red lines. What are the absolute things you would not sign up to? Unlimited liability. Indemnities on the basis of X, Y, and Z, delivery timeframes that we couldn't adhere to, fitness for purpose obligations, whatever they may be. And usually those red lines come because they are uninsurable or will impact our balance sheet if there is a claim against us. And that tends to be something that very quickly can be done within any commercial team of a business.
And Anya, I'll come to you in a second, but David, just following on from that, you introduced this term to me, the entire agreement provision. You put it in quotation marks in your slides, even they signify its importance there. That's the first thing you recommended to everyone, that's the first thing to go look for. Will it always be called that, or will it be called something different? Or
no, not necessarily. And sometimes it's hidden away in the boilerplate clauses that we tend to skip over. I'm looking at the payment terms, I'm looking at the delivery schedule, I'm looking at the scope of services. That's what I care about. And the boilerplates at the top tend to be avoided. So not always called that, and not always in as easy and identifiable language as this is the entire agreement. Some are very blatant to say this is the entire agreement, to the exclusion of all other communications, discussions, negotiations prior to the contract date. But most standard forms have entire agreement provisions, and anyone doing works within the public sector, in any public contracts that are construction or service over a certain threshold will use the NEC, the new engineering form of contract. And that at 12.4 is the clause reference, that is their entire agreement clause. More bespoke contracts tend to add them in, as I said, in boilerplates, but no, not often easily identifiable. But one of the things, Stephen, we could do is provide to yourself to share with members what those clauses often look like, just to know what ones to look out for. Because sometimes, as I said, it ousts clauses that or discussions that had before. Well, my understanding was, Stephen, I thought we'd contract on the basis of X, Y, and Z. Well, the contract doesn't say X, Y, and Z. Well, if there's an entire agreement clause, I have agreed with you to opt out the discussions we had before. Sometimes that's done purposefully. It's done in such a way that I actually have led you down the garden path. If it's proven that that's the case, potentially it can be rectified. But that's a high burden again you have to pass, and that's a lot of legal time, money, hassle that you're going to have to go through. That if you just identified at the start, maybe you wouldn't have to ever spend.
I think that would be really helpful. David, thanks for that. Anya, you talked, or you both talked a lot about this all rises or falls on the burden and standard of proof. And obviously, particularly in around construction facilities, with lots of construction manufacturers, materials, whatever else, the types of record keeping in busy, potentially dirty, certainly sometimes dangerous workplaces like construction sites can be, is incredibly difficult. They may be scraps of paper. We have a question here about the use of Excel spreadsheets and calendars that people may use in site offices on site. I mean, how well do they stand up to credibility, or do people really need to tool up in terms of potential technology, some of which that you introduced us to earlier?
Yeah. That's obviously a common issue, is that there's stuff written on a page, like David talked about site diaries, and you have things written down in a book. And we're in an age now where everything tends to be stored in a cloud or on your databases, and you're not really looking at paper so much anymore. I think probably, we're seeing a lot of these apps are talking about photographs and uploading things, taking photographs of information. If you have a record of something, the metadata from your photograph will tell you the date on which that piece of paper was signed or that information happened, and that gives you that contemporaneous record. And how well it would stand in court. Now, this is all building your picture. This is all about your factual evidence, being able to establish the truth, as we talked about before. And this all comes together. Those records of things that happened on site. I think, we're talking about a scenario earlier with a book that was potentially signed at the date, not contemporaneous. If you have a photograph of that scrap of paper, and that photograph tells you that photograph was taken on X date, all of that information is now used quite often in disputes. Now so from a disputes perspective, we start to use systems like Opus and Relativity, where all of those documents are stored on a huge database, and metadata has become very important. So yeah, all of that it comes into the story. All of that's used for your narrative to justify your claim. So absolutely, anything that you can store and maintain, certainly.
There's easy things that can be done. It's just, and you're not reinventing the wheel, you're just slightly realigning it. So where there are, Stephen, you said in construction sites, you're in a manufacturing facility, and there is a question of what did or did not happen. It is educating, informing, and training staff, and that's one of the things that we would do. We would go in to actually sit down with the site operatives and say, these are the types of things you would need to do whenever you are thinking about a record keeping on an operational system. Everyone on this call has at least one mobile phone that's either sitting in their pocket or sitting in their desk in front of them. What is more compelling? The scrap of paper that I write on to sort of say, oh, well, that was said X, Y, or Z? Or is it me picking up the phone and taking the picture of the thing at the time that then is stored at, and again, as Anya said, the metadata demonstrates that was said that taken at that particular time in that location. It's a case of just getting into the habit. And again, nothing is revolutionary in this. It's just slightly realigning best practice, and educating the guys on site. Look, there's the extreme on the other end there's a very a very, we'll call it controversial, high-profile project happening in the city of Dublin that has gone way over budget. There are people involved in that from a claims perspective that have drones flying above the site, had drones flying above the site. And there are two people, one on one party side, one on the other, whose full-time job is employed to walk around with a body cam. And they walk around the site with a body cam the whole time, standing over people whenever they're having a cup of tea. And that's their job, and it's all part of that record keeping, is the contemporaneous data of this video around the site at that particular time. Now that's an extreme, that's a €2 billion dispute, but that's the type of things that you can kind of very easily do just to improve that record keeping.
Just to close off the question that's in the chat there, so things like Excel obviously are easily changed and edited. So if people are using Excel, it's probably wise to kind of share the documents on a daily basis so that it gives you some sort of timestamp at least.
Even internally.
What's happening.
I don't need to send it to the other side. I can send something internally, and then evidence, well, here is the email I sent to myself at the time with that version of the Excel. If there is an Excel or a document that is going to be shared, it's very easy to password protect it such that it becomes uneditable. So I am showing you that. Or the other alternative is you convert your Word or your Excel into a PDF such that it contains the raw data but is not editable itself. And again, these are just very small things that slightly just realign what we're doing. We're not changing it. We're just doing save as PDF, and it will lock the data in. So I'm sending to you that at the time. So the ability to edit isn't compromised.
I think, sorry, very quickly on Excel spreadsheets, things I suspect move very quickly on construction projects, and people move and change things regularly. What we do as a practice, whenever because we would have multiple people involved in documents, we save it as different versions on different dates. So recorded on a specific day, you have this date, this was the version, this date, this was the version, and keep it as a track. I appreciate you could end off with a version 2052, but it then means that you're not having to necessarily PDF if that becomes a more of a document burden. It's setting up your system at the start, determining what are the practices we're going to implement from the very beginning, so everyone understands the processes, and that can be very straightforward. I think it can sound very convoluted and very complicated, but actually it can be very straightforward if you just have the systems in place from the start.
We've about 60 seconds left. If you were to leave, both of you, if you were to leave those watching with one kind of quick piece of advice that they should take away and do today, what would that be?
Go and organize your documents immediately. Make sure you have a folder structure, and maybe consider investing in some sort of AI tool.
Don't be afraid of ever using the contract. There's often the issue of, somebody becomes too contractual. We've entered the contract because those are the terms that we intended to be bound by. So don't be afraid to use it. Don't be afraid to rely upon it, because it is there to protect you as much as it potentially is there to punish you. So don't be afraid of using the contract or referring back to it. That's what it's there for.
And if you could just move to the next slide there, the contact details for both David and Anya are available, and we'll share them obviously with the recording and the slides as well. My one piece of advice is obviously pick up the phone and seek good advice from those that live this life on a daily basis. Today's been a very practical, helpful, I think, seminar for anybody who has the responsibility to ensure that the work gets done and you get paid for it at the other end of all of this. If people do have any specific inquiries relating to their contracts or disputes, then certainly pick up the phone and give a shout to David and to Anya. We probably have gone over very slightly. We've over recorded, but I think that's the message from today: is record, because that proof of burden, that burden of proof is on you to ensure that you're protected and you get what you're entitled to. David and Anya, thank you so much. I really appreciate it. We'll
Thank you
share
for your
the
time.
recording and we'll share the slides after the event.
Thank you.
Thank you very much.
Thank you.
Bye-bye.